So we're seeing a note now, English Montreal School Board putting out a release just actually a little earlier this afternoon saying that the Quebec Superior Court has provided a decision which will give them a partial stay of provisions of Bill 96 in the Charter of the French Language. Try to find out a bit more and exactly what this does mean. Joe Ortona is chair of the EMSB. He's on the line. Joe, thanks for being here this afternoon.
Thanks for having me on.
Last time we spoke, it was the news that, of course, you're going to be taking this to the Supreme Court, and then we just assumed not a whole lot would happen since then. So what does this decision mean today, and does it relate to that?
No, the decision to go to the Supreme Court has to do with Bill 21, the religious symbols ban that prohibits us from hiring teachers who wear religious symbols. This is about Bill 96, which is all of the new language restrictions regarding, the obligatory use of French and the places where the use of any other language other than French is prohibited, and that's what this is about. And so we're obviously very pleased that we were able to obtain a stay of several provisions where, as an English language school board, we would have been obliged to use French exclusively in certain matters or be forced to use both English and French in other communications. So essentially what this means for us as school boards, because it's good for all the school boards across Quebec, is that we're able to do things as we did before. It's basically status quo until we get a decision on the constitutionality of the parts of the law that we're challenging.
So when did when did you ask the court to make a ruling? Like, how long has this been before you actually figured out, or we're told today that they decided this?
We had initially filed the Bill 96 challenge back in 2022 as soon as it was launched, but the challenge to stay the provisions was launched last November. So when you're asking for a stay, you're basically saying that there's an immediate irreparable harm. So there's an urgency. It's heard much faster, and the decisions are rendered much earlier because it's an urgent matter. So we filed in November. This was heard in first week of March, and we got a decision last week.
So, Joe, I'm thinking, and again, I know nothing about how this legal system works with respect to this. I'm waiting, first of all, for the government to react. Have you heard them react?
To my knowledge, they have They have not reacted, and we don't know what they think or if they're looking at appealing or anything like that.
So they have the option, though, to appeal, though, right? Even this stay.
Yes, they can. They remember that they appealed when we were able to obtain a stay on Bill 40. They went to the Court of Appeal, but they lost there as well.
So I'm not going to ask you if you were a betting man. Do you think they'll do exactly the same thing now and appeal again by virtue of the fact that they lost, or do you think that's kind of like, let's not bother. We learned our lesson, and we won't appeal here?
Well, I mean, if they're looking at the bigger picture, then they shouldn't be appealing. I think appealing a stay provision that applies only to English school boards is really, if they do that, I think that's pretty petty. I think that's just, looking for a reason to stick it to English school boards, quite frankly. They're going to want to defend the constitutionality of this bill at some point when it's heard later this year. And obviously we're going to be presenting some very good arguments as to why the law should be struck down.
To be honest, though, when you said that you think this would be petty, they'd be sticking it to English school boards. I think there's a secret desire within the department, at least the education ministry, to do just that. But let's hope they don't decide to do that. But if they did, you would not be surprised. This has already happened once before. Let me ask what this does apply to, because I'm a little confused here. Up until the stay, were internal communications or external communications the one that were affected by this law?
Both. So external communications with businesses inside Quebec. In those communications, we were required to write and speak exclusively in French. In our internal communications, any internal communications involving more than two people, we were required to use either French only or both English and French. And of course, who's going to bother to write an email twice in both languages? That just doesn't make sense. It's really as a means to prohibit indirectly the use of English, essentially. So it really covered, it was very broad. It covered all communications, internal and external.
Okay, and this now with the stay, it no longer covers both, or I'm trying to understand. You can do now whatever you want just in English?
Well, we're able to do what we were doing before. It's status quo.
Okay.
So, I mean, there were times when certain communications would go out in English only. There were other times when it was appropriate that communications go out in both languages, and that's what we're going to continue to do.
So, based on a stay, what does this mean long term in terms of, how long will this remain in effect? What happens next?
So the stay is in effect until the hearing is heard on the merits, meaning the hearing on the constitutionality of Bill 96. So until we get a final ruling on all of that, the stay is in effect, and we're going to continue to operate. It's essentially the same thing that happened with Bill 40, right? Mm-hmm. I mean, when we were granted the stay, we got to remain school boards until we got a final judgment. And, of course, that judgment from Superior Court was in our favor, and so that's why we're still school boards today. All
right. So we call this a win then. I mean, it's fair to say that, right? This stay is a win for the EMSB.
Absolutely. It's a significant win for the EMSB, for the QESBA, and all English school boards across Quebec, because a stay is very difficult to obtain. The threshold is very high, and we've been able to obtain a stay twice now against the government of Quebec. Last thing
I will ask you, when we spoke last time about Bill 21 and the appeal, it's of course now going to head at the Supreme Court of Canada. It didn't take long, and I think I mentioned this to you at the time, for the government to react saying they were disappointed. I'm not sure if that's the word they used, but let's say upset at the fact that this was actually going to be challenged. Have you heard anything since then from the government?
No, and I wouldn't expect to.
Okay.
I mean, they're not happy that we're challenging. What can I say? Tough bananas. We live in a democracy. There is a process for contesting legislation. It's a democratic process. It goes through the courts, and ultimately, the Supreme Court has the final word in the legal process. That's just what it is.
I'm beginning to wonder if we're seeing a softening in the ministry. I don't know if you heard Bernard Dranville today, not to do specifically with the EMSB, but the situation where that meeting for parents with disabled kids had to happen in French. Now the government has apologized. He's in essence said that, and he said that in the future they'll be able to do it. Maybe there's a change of change of heart, if nothing else. I mean, that'd be a nice thing to consider.
Well, what I'm going to say about that is it shows that it's important that as an English-speaking community, when these kind of injustices are occurring, that we speak out. And I think it's because of the public outcry that people, either within the government or within the Ministry of Education, came to the realization that, hey, this is another embarrassing situation that we need to correct. Nobody likes to have egg on their face. It's not fun. I understand that. But, this is just another example of people not understanding the rules behind Bill 96, and they're misinterpreting them, and they don't understand that the English-speaking community, we were told this repeatedly by the government, you're going to continue to receive services in English. Well, somebody there isn't getting that memo, because what happened there with the special needs parents should never happen. I'm glad that the minister admitted that and recognized that and apologized for it. That's a good step. But really, I don't know who's responsible, if it's the Ministry of the French Language or whoever's giving these directives. But they're getting it totally wrong, and that shouldn't happen. This is the this is the basic stuff. We're not even in the complicated parts of 96, and they're getting it so blatant.